Imagine this. ICE agents raid a home targeting a gang suspect, but along the way they detain others, undocumented immigrants who aren't suspects, aren't witnesses, and aren't even involved. Is that legal? Is it constitutional? Let's break down this increasingly contested intersection between immigration enforcement and fundamental rights under the U.S. Constitution. ICE operates in two worlds: civil immigration enforcement and criminal law enforcement. When they're targeting crimes like drug trafficking or illegal firearms, they're under criminal authority, often working with FBI or DEA. But what happens when they sweep up others along the way? Individuals not on any warrant, not under suspicion, just present at the scene? These are called collateral arrests, and they raise serious constitutional concerns. Under the Fourth Amendment, everyone in the U.S., citizen or not, is protected against unreasonable searches and seizures. In Ibarra v. Illinois, the Supreme Court ruled that just being present during a lawful search does not justify arrest or search. The government needs individualized suspicion. That means ICE can't detain someone just because they're undocumented and nearby. The Constitution doesn't allow guilt by association. Sometimes ICE raids look like criminal enforcement on the surface, but the real goal is immigration enforcement. This is called pretext. In criminal law, pretextual stops are sometimes allowed, like in Ren v. United States. But in civil immigration enforcement, courts are much stricter. If ICE uses criminal raids to mask civil sweeps, it could be an abuse of power, and courts might suppress evidence or even dismiss cases. Here's where things get tricky. If someone is detained and questioned during a raid, does ICE need to read them their Miranda rights? If statements are used in civil removal proceedings, no Miranda required, according to Lopez Mendoza. But if ICE plans to file criminal charges like illegal re-entry under 8 U.S.C. section 1326, and they question someone in custody, then Miranda must be given, or the statements could be thrown out. The 5th and 14th Amendments guarantee due process and equal protection. That means government actions must be fair, non-arbitrary, and non-discriminatory. If ICE only detains certain people based on appearance or race during raids, courts may view that as racial profiling, a violation of the Constitution. Cases like Flores v. Baldwin Park show that immigration enforcement is not immune to civil rights scrutiny. Even if these arrests are technically legal, they often result in indefinite detention, lack of access to counsel, or separation of families. These operations also erode public trust, make communities less likely to report crimes, and invite civil rights lawsuits against ICE or local police partners. Collateral arrests sit in a legal gray zone. But gray doesn't mean unregulated. Constitutional rights don't disappear at the edge of a raid, they apply to everyone. In a nation governed by the rule of law, the ends cannot justify the means. If the government breaks the Constitution while enforcing it, the foundation crumbles for all of us. Know your rights, understand the law, share the truth, subscribe for more legal deep dives.